Hi, I'm Karen Hussey. This is Steve Williams, and this is Bobby Truey. So we're KBS, the way we're sitting here, which is probably pretty accurate. We are delighted to have you guys participating in the first of our 2018-19 school year webinars. This topic today is one that a lot of people want to pretend doesn't exist until they get the grumpy email from some publishing company, and then they call us and say, we should really have more training on copyright law. And so our purpose here today is to give you guys the tools that you need to actually function in schools without violating the copyright laws. So let me just let you know what the plan for today is, and then we'll get rolling. First, we're going to cover the basics. I'm hoping that we move pretty quickly through this. I think the first little bit of the show is going to sound like just us telling you the law, but just trust us, we're going to get to good application, but we got to start with some of the basics. And then the majority of the time we spend together will be dealing with issues that schools commonly deal with. So I'm going to talk about making photocopies to use in the classroom. We're going to talk about teachers to teachers, selling lesson plans and curriculum and a kind of something like that. We're going to talk about whether or not you can stream Pandora or something like that in the classroom. We're going to talk a little bit about de minimis use, how much is de minimis. Then we're going to talk about movies and TV in the classroom, public performances like your show choir, speech team, that sort of thing. A little bit about using clip art on the internet, and then finally test the student record. So that's the game plan for today. We will be done by noon.
Slides are available on the website. We just had that question come in.
Yeah. Sherry emailed out slides to everyone, but they are also up on the website, which is ksbschoollaw.com. And then if you click on the calendar tab on today's date, it should be the most recent version of the slides.
And all circulars and all their documents we're going to talk about.
Okay, so you're next. Who's next?
All right, so what we're not talking about today is trademarks. So essentially, Nebraska Cornhuskers, Herbie the Husker, the black shirts, that kind of thing. We're not talking about trademarks. We're not talking about service marks. We're not talking about the name of your school or your mascot. That's what we're not talking about.
That is if we still want to own those Nebraska things at this point.
So what are we talking about? From the U.S. Constitution, this shows you how important they thought it was. They put this in the very first article of the United States Constitution, and it says that Congress has the power to promote the progress of science by securing for limited times to authors the exclusive right to their respective writings. So that shows you how important they thought it was, but that's it. That's all the guidance we have in the Constitution. So we have to look elsewhere to find out, fill in the gaps and find out what else this means. So we've had, when we say multiple congressional acts, there's a lot. The first one was in 1790. They've redone the Major Act many times, and then there's been amendments to those many times. But if you're ever bored one night and having trouble sleeping, you can click on that link. It's a 370-page document that discusses way more than you've ever wanted to know about copyright. It provides a lot of detail. It is complex at times. It's frustrating to attorneys at times. They'll give you tests and you think, oh, great, there's a test. This should be easy. It's a 4-part test. You'll find out there are no bright line rules in many of these areas. So just keep that in mind as we go through these. The big act that's really in place these days is the Copyright Act of 1976. But as I said, these things get amended. I counted them up last night. At least as of 2008, this had been amended 69 times. So it's nonstop, and they're always tinkering with some part of it or another. But these contain the rules on how copyright materials are going to be allowed to be used. It protects original expression, as we'll talk about, I think, a little bit. The originality requirement is not super high. It's eligible when creation is fixed in a tangible format. That just means it's put into some format that you put your hands on. The length of the copyright varies. In most cases, it's really based upon when it was created. Although you're not required to register a copy mark or a copyright, it's created as soon as you create it. If you want to sue somebody for it, it does have to be registered at that point. So keep that in mind. Here's a handy dandy little chart that shows you how long a copyright will last. This chart isn't perfect, but what I like is it shows you the trend. You can see how it was relatively short back in 1790. It's grown and grown and grown. The current standard is the author's life plus 70 years. So that's a pretty extensive copyright law. Anything pre-1923, so if it was created before 1923 on today's date, it's in the public domain, and we'll talk a little bit about that. I did want to share with you that there's a good website for public domain music information, and that's pdinfo.com. And it tells you if a piece of music is in the public domain or not. And believe it or not, Wikipedia does a great job on all of this, but especially books, of telling you, and they tell you what's coming up and what already is in the public domain. So the trend, as we said, was longer time periods for copyright protection. You know that fancy little C with a circle around it, you'll see that it stands for copyright. You'll see it on most documents. For works published after 1989, it's not required anymore. So just because you don't see that C or that copyright doesn't mean it's not copyrighted at this time. So just keep that in mind.
And if there is a copyright symbol on it, that clearly means that they care about you not stealing it, but no copyright symbol doesn't mean it's free for the taking, which is something that sometimes students have told us they thought was the case. So many times we get phone calls. In fact, my daughter is a big hockey fan, so she listens to a hockey podcast, and they were playing Imagine Dragons' Thunder, you know the song Thunder, Thunder. Imagine Dragons is a very aggressive enforcer of their copyrights. So this podcast got a takedown notice about the Thunder. And Anna was like, my daughter said, that's so stupid. Imagine Dragons is being done because they could sell more songs if they let more podcasts play it. And I get that from school administrators too. We should be able to use whatever music for the dance team to do their dancing at halftime, because that would just sell more copies of the music. But remember, copyright is not about money. Copyright is about control. And the best thought experiment for all of you is, if a white supremacist group wanted to use the song Thunder to support their cause, I think everybody would agree that Imagine Dragons should have the right to say, we don't want to be associated with that. So copyright is not about money, it's about control. And the idea that it's so stupid that when we call these music publishers and ask them for permission to use their music, they won't agree. They just don't want to mess sometimes with having schools use their material, because it's about control, not about money. It's also not about giving credit. We do such a good job with kids in the classroom talking about plagiarizing is using somebody's work without citing it. But just because you cite somebody's work doesn't mean you are permitted to use it. Again, the fact that the white supremacist group has Thunder by Imagine Dragons scrolling across the Nazi video while the music plays in the background, that doesn't make Imagine Dragons any happier about the fact that their work is being associated with white supremacists. So just because you give credit doesn't mean it's enough. And just to go up to this slide here, you'll notice that this is not our original work. We took it from Tom Bell, although he has used a Creative Commons license to say that people can use it. But it's not enough for us to give Tom Bell credit. He has to have allowed other people to use it, and that's what he did with his Creative Commons attribution. It's also really not about criminal law. I have a school superintendent that calls me all the time, and she says, well, I want to talk to you before I go to Leavenworth. We aren't sending anybody to jail for violating copyright law. It's all about money. But the fact that schools basically have unlimited money because you have levy authority actually makes schools a more inviting target for copyright enforcement, not a less inviting target. Now, there are some groups that give special privileges to users, especially for educational users, and PBS is a great example where they basically have said in their all of their copyright material that they will let any educational group use their stuff as long as it's not inconsistent with an educational purpose. But just because you're an educational group doesn't mean everybody loves you as much as PBS loves you. So the idea that I'm a school, I can use this stuff for free because I'm not making money off of it, that is absolutely not the case, even though a lot of people kind of want that to be the case if they're in education. That's not how the law actually works. So copyright protects the creator of a creative work, and it doesn't take very much creativity to make it a quote-unquote creative work. We'll show you an example here in a minute of a picture of a basketball that doesn't look very creative to us, but it does have copyright protection. It does not include facts, so like the temperature at which water boils, that's not a copyrightable thing. It does not include ideas, but it might include the unique expression of ideas. And actually the most interesting case law in copyright right now, there is a whole body of case law involving animal selfies. This is a monkey that a wildlife photographer had just left a camera sitting out in the wild, like to take a time-lapse photograph. And this monkey figured out how to take a picture with the camera and took this image. The owner of the camera copyrighted this image, and then PETA sued the owner of the camera, saying that he was committing an act of animal abuse by stealing the animal's intellectual property. Believe it or not, there is also a bunch of litigation about elephant painting. Like if you put a paintbrush in an elephant's trunk and give it paint, there are elephants that like will, you know, make paintings. PETA has also sued to copyright those as works of art owned by the elephant. And the United States Court of Appeals for the Ninth Circuit dismissed a lawsuit involving this monkey picture. The lower court said animals cannot own intellectual property because there's no creativity no creativity used by the animal because they can't have creativity. And Laura, we got this picture. If you Google animal selfie, this will come up. It's actually on a Wikipedia page. And I can use this without permission because the animal does not have a copyright in it. And the photographer does not have a copyright in it because the photographer didn't create it. And the animal does not have the cognitive ability to be creative. And so animal selfies currently do not have any copyright. There we go.
Okay. So we talked about all this. Yeah, any use is either in search of a license or an exception. So anyone who violates the exclusive rights is an infringer, and therefore that person can take a certain number of actions to get you to stop. And so we get the question all the time, but we're a school, and this is straight again from the definitions talking about the term anyone really does mean anybody, including somebody who's an officer, an employee of an instrumentality of the state. And so in Nebraska, that could be a political subdivision, which is a school. So any of the school's employees, any board member, anybody else could either be liable individually or could subject the district to potential liability. So to establish a copyright infringement, it's pretty easy. And when we walk through the cases here, it's going to be easier to tell because you're only fighting about one of two things. Number one, the person who's trying to get me to stop using it or trying to get damages from me doesn't actually own it. We'll talk about cases where teachers, for example, have been involved in copyright lawsuits where they're trying to enforce rights that they don't have because it was actually their school district all along that owned the copyright. So we oftentimes fight about, number one, the ownership side of things. But then if we assume ownership is met, and again, in some cases it's easy. In some cases they concede that ownership is met. Then we move on to number two. Is the copying, is the use of that work somehow unlawful? They reproduced it when they shouldn't. They didn't, they exceeded what was allowed by the license. So there's really only two fighting points in each of these cases. And as Steve mentioned, they get much more complicated in each of those subpoints, but for the most part, that's it. So we're just going to put this list up here. We're going to talk about several of these as we move through. But we've actually had a lot of cases here in Nebraska. I know over the years there have been copyright presentations at statewide conferences where we've put up examples that we've had, but whether it's poetry, pictures, songs, warm-up music at basketball games, any of that stuff is subject to the copyright holder or the person enforcing that person's rights telling you to knock it off. And so a lot of these, like I said, we've got examples coming up as we move through the materials here.
So this is an example of a copyright infringement takedown notice that we received just this school year. And the school district was nice enough to say, hey, you can share this. Thank you. This is certainly not the only example of a school district getting a takedown notice. But if you look at that under where it says catalog image 881-98224, that's the picture that they've copyrighted. Now this goes back to the idea that this doesn't really take a lot of creativity. It's a picture of a basketball and a flippin' net. And so, you know, notice that we don't have interpretive dancers going around the rim or it's a different color. This is a standard, just a photograph of a basketball and a basketball net. But that level of creativity is enough for that to be copyrighted. And so then what these companies do is they have bots that go through and check your website And this school had it down under their basketball team sub page on their website. Somebody had it's the first image that comes up when you Google basketball. And they just right-clicked, copied, and then pasted it onto their school district website. And so this is the proof, this is the document that you get from the copyright holder saying, here's our image, here's proof that this was on your school district website, here's a screenshot, and here's the URL that proves that it was, that we went and found it on your space. We've gotten this with, like Bobby said, a little poem that somebody put in the school newsletter. We've gotten a lot of clip art ones, and it seems to be basketball. That's the ones that most often are, but we've had all kinds of like the letters thank yous, the words thank you spilled out with like Scrabble tiles. That was one. And so it doesn't have to be super creative. And notice that this picture doesn't have the little C in a circle on it on the original image because it was taken after 1989. They don't have to have that copyright image on it to warn you not to copy it. Was this me? Yeah. If a school does get a takedown notice, I don't want you to feel like you're the only one or how could you be so stupid. Texas, Missouri, Georgia, USF all had their Twitter accounts suspended because they were playing, they had pictures of their student athletes with music behind it, but they had not asked for permission to use the music before they put the little videos together. And of course, the athletic departments thought, well, we're schools and these are our own pictures and it's just a little clip, so it's not the entire song. And none of those were defenses to having to take this down.
I think what makes this interesting too is if you notice the date for those college football recruiting junkies, this was National Signing Day. So a lot of the videos and images that were posted were these people on the internet that make edits for kids announcing their commitments to a school or announcing their official signing. So in some of these cases, the Texas, for example, Texas football account retweeted a post that the student athlete, the 17 or 18-year-old himself had posted. So it's like the kid, right, was the first one to create the copyright violation because they took some song that one of Sony's protected artists has copyright interests in. They posted it, the kid posted it to his own site, and then the university that was recruiting that kid retweeted it. And so they're not gonna go after the kid, right? They're gonna go after the institution. So Sony sent all of their takedown notices to the schools, even though there was no upline administrator that ever authorized it. It was some media specialist. It was Anna's daughter in the Texas recruiting department that retweeted these kids that had posted the videos. So to me, that shows how far you can drill down in the concept that, yeah, they're obviously going to go after the school.
Because that's where the money is. Yeah, exactly. That brings us to fair use. That's still me.
Yeah.
So this lens case, you guys have probably heard about this. This is the lady that took the video of her very young kid, like 3-year-old kid, dancing to Prince's song, Let's Go Crazy. And Universal Music aggressively enforces all of its copyright in favor of Prince, the estate of Prince now, but at the time Prince was still living. And so they had a bot that went through, and every time any piece of Prince's music was played on the internet, they would send a takedown notice. So they didn't even watch the video. They didn't do any kind of analysis to see whether this was okay or not. They just automatically sent the mom a takedown notice. And the court in this case, ultimately the family lost. They had to take the video down. But the court said in order to enforce your copyright, people like Sony and Universal, you have to do some groundwork. You have to look at it and make sure that the person using it is not under the fair use doctrine, which we'll explain here in just a second. But so what was interesting about this case when it came down, we really thought it would slow down the number of takedown notices that we were getting because the people that are demanding that you take it down have to do some legwork first. But it really hasn't slowed down the number of takedown notices. And as you'll see here, this example that we have, they've done their due diligence, right? They've said, look, this doesn't appear to be fair use. It appears to be you advertising your basketball team. This is what the copyright holder now has to do to prove to you that they've done some spade work to make sure it's not under the fair use doctrine. So what happens if we get caught? This is the scary part. The basic level of damages is between $750,000 and $30,000 per work. There are some really frightening cases involving colleges where kids have used the university's network and computers and technology infrastructure to illegally download music. And schools were tagged at $750 per song. So if a kid has downloaded 5,000 songs using the school-owned computer or school-owned internet access, you can see how that adds up pretty quickly. If it's willful, we had a teacher who just used the school's computer and technology infrastructure to download all the Game of Thrones seasons to date. And they were alleging a willful infringement. Now, we were able to resolve that on the school's behalf, but that's 150 grand per work. So, I mean, now we're talking serious money. And if you can show that you weren't aware and had no reason to believe you were infringing copyright, that's not a get out of jail free card. You can see that you can have the damages reduced to $200 per work, and $200 once is no big deal. But if a kid has downloaded 5,000 songs, $200 per work turns into, again, pretty serious money. For the most part, when we get a takedown notice, we contact the copyright enforcement agency. We usually plead poverty and it's a school and whatever. But I don't think we've gotten anybody off scot-free. Most of the time we are just able to talk them down to less money. But I don't think, maybe once we were able to get them to go to zero, but that's not typically we just talk them down and we pay less than they originally demanded.
The only time I can remember we had one, somebody put up a picture of Rob Gronkowski from the New England Patriots. And I thought, there's no way they're going to let us get away with this. And it was actually ESU1 contacted them directly and said, hey, we're just a poor little school and leave us alone. And they go, oh, you're a school. Okay, that's fine. And so they actually did let them get by. That's the only one I've dealt with where they got away with it.
But if you do get a takedown notice and a demand for damages, it's worth the money that you spend having one of us or even your administrator call, because most of the time we can talk them down pretty substantially. And I think half is what we've always shot for.
Yeah. And the tough part is, like in the case Karen was talking about, the University of Nebraska kids downloading music, the university turned and pointed the finger at the kids. They're like, look, we had no idea this was happening. They're using software to clearly and intentionally violate people's copyright. That's tougher for you as a school. And there's going to be some boards who say, you know what, we'll stand in protection of those kids. So I think that's what you need to be thinking through too. To the extent this is a board issue, I think you're asking questions about settling claims where in some cases you may be able to point the finger at kids or staff members who have done the wrong thing. And so we'll talk about liability theories, but a lot of universities will just point at these students who are themselves adults. A lot of K-12 schools wrestle with, should we show up and pony up money to answer for the unlawful actions of our employees and students, even if we could otherwise, show that they knew what they were doing. So. And
the problem in the Eighth Circuit with pointing the finger at somebody else is there's a horrible case from the University of Minnesota where the University of Minnesota went all the way up to the Eighth Circuit and said, look, it's not our fault, it's these rotten kids. And the university got clipped. I think the award was over $1 million and they settled it. So I don't know what they ultimately paid out. But saying the kids did it, I don't think in a K-12 context is going to defend us.
All right, so what happens at the school-based level? We updated our policy recently hopefully to increase compliance and to preserve some technical defenses that we might have. And so if you're a policy subscriber, you had this past summer. If you're not, you might want to take a look at your copyright policy and just make sure that you're up to date and have some defenses in there. But we've highlighted the provision that I think we want to emphasize, and that's a staff member who wishes to use any non-original work must obtain the prior written permission of the building principal. So we're putting in a safeguard there that makes sure that hopefully our principal has a little bit more knowledge about the copyright law. And unless you've obtained a license or for its intended educational purpose, no principal shall grant permission for requested use of a copyrighted work unless he or she has reasonable grounds to believe that it is a fair use under applicable copyright law. So you can see the principal is going to be expected to have some level of knowledge about fair use. And so that's going to take some studying on his or her part because it's not as clear cut as we'd like sometimes. The distribution of copyright compliance materials. We do have to make certain information available to those individuals, to staff and students, so that we do have defenses available. We do also provide that material with our service. Is there something you want to add on that?
Just that what we're doing here and having two layers, the teacher and then the principal have to analyze it, is that helps your argument that it was not any intentional violation. somebody there being able to articulate that they at least thought through it, even if they got it
Even if you
completely
get it wrong, that's right.
Did you think through whether this was a violation? Did you think you had fair use? Make some notes about that. Easy breezy. I mean, it doesn't necessarily mean you're not going to get tagged with some violation, but it gives us something to send back to the copyright company saying, look, we're going to get your damages half down even if you were successful.
Yeah, you just have to have a reasonable belief that it wasn't fair use.
Right.
So, and what can happen? Well, if you're a student, you could be expelled, and if you're an employee, you could be terminated. So, I mean, it's a pretty serious issue, especially if it's one of those $30,000 violations or $150,000 violations. You're much more likely to get tagged by the school for that kind of incident.
Okay, we're going to hit